100 years ago, history was made in the small town of Dayton, Tennessee. For a week in July 1925, the world's attention was focused on this Tennessee Valley town, as John Scopes, a substitute teacher in the high school, went on trial for violating a Tennessee state law that prohibited the teaching of any theory of the origin of man that contradicted the account in the book of Genesis. In July 2025, Dayton celebrated the centennial of the Scopes trial, and we were there for the commemoration. In 1925, here in the small town of Dayton, Tennessee, there was a trial, small in itself, but which had far-reaching consequences for how we educate our young. The trial took place in this beautiful Romanesque Revival building behind me, the Ray County Courthouse, built in 1891. From the 10th of July through the 21st of July, 1925, John Thomas Scopes was standing trial for supposedly violating the Butler Act, which prohibited, in the words of the Act, teaching, quote, any theory that denies the story of the divine creation of man as taught in the Bible, and to teach instead that man has descended from a lower order of animals, close quote. Violating the Act was small potatoes, but Scopes was a show defendant in a larger struggle, mainly over the question, who gets to decide how children are educated? Should it be parents who decide? Local communities? In this case, the state of Tennessee? Or some arm of the national government? On opposing sides of these questions in the Scopes trial were two titans of 1920s America. William Jennings Bryan was part of the prosecution team. He's honored here at the courthouse with this statue by Cessna de Cosimo, erected in 2005. On the defense was the Johnny Cochran of the 1920s, Chicago's Clarence Darrow. When I last visited Dayton about 10 years ago, Bryan's was the only statue on the courthouse grounds. I remember thinking then that Dayton had made clear who their hero was. But the people I've met in Dayton on this trip are unfailingly polite and fair. So, in 2017, a statue of Darrow by Zenos Perdekas was put up just across the walk from Bryan's. For 10 days, the battle between Bryan and Darrow attracted a national media circus to Dayton. WGN of Chicago broadcast the proceedings live from the courtroom. H.L. Mencken sent his characteristic acid-tinged commentary to his newspaper, the Baltimore Sun. And Joe Mendy, the gentleman chimp, was there to represent the missing link in human evolution. Oddly enough, both prosecution and defense wanted Scopes to be convicted. The ACLU wanted Scopes to be convicted so they could challenge the Butler Act as an unconstitutional infringement of free speech. And for that, they needed a show plaintiff, which was John Scopes. And they needed him to be convicted so they could challenge the Butler Act on appeal. The prosecution's motives were simpler. They just wanted a conviction to uphold the Butler Act. Both prosecution and defense were represented by able teams of local and state legal talent. They carried most of the heavy water in the case, but they are distant extras in the public image of the Scopes trial. What dominates the public image of the trial was the pyrotechnics of Bryan and Darrow as they squared off against each other. At first, the ACLU didn't want Darrow on the case, given his controversial public reputation, but once Darrow learned that Bryan had joined the prosecution, he felt compelled to muscle in, if you will. And with that, the circus that became the Scopes trial was launched. The circus was coming to town. The Scopes trial controversy began, to quote John Scopes himself, on a warm May afternoon in 1925. He was playing tennis with a friend on the clay courts at the Dayton High School, located here on this now vacant site along Church Street. The high school isn't there anymore. It's been replaced by offices of various social service organizations like the United Way and a gymnasium. During his tennis game, a boy came up to Scopes and told him that Doc Robinson, who owned Robinson's drugstore, had asked Scopes to come down to the drugstore to discuss something. Robinson was also president of the Dayton School Board, so Scopes thought it would be something about school business. There was no urgency in the request, though, so Scopes finished his tennis game and made his way down to Robinson's drugstore, still in his sweat-stained clothes. He probably would have walked up 4th Avenue to Market Street, passing by the W.C. Bailey's boarding house where he was staying. Oddly enough, Joe Mendy, the gentleman chimp, also stayed here during the trial that was to come. Then left onto Market Street, which was Dayton's main drag. Along the way, he would have passed Doc Robinson's home on the corner of 3rd and Market. He would have passed the Ray County Courthouse. 2 blocks later, he would have turned right onto Main Street and to Robinson's drugstore, just around the corner. Robinson's drugstore had a soda bar, which made it a popular gathering place for people to get together and socialize. That day, a number of town luminaries had gathered at the soda bar to discuss the Butler Act, which had been signed into law just a few weeks previously. The ACLU had been sniffing around for a test case to challenge the law, and for that, they needed a plaintiff. At first, they looked for their willing plaintiff in nearby Chattanooga, which was the site of a state university, and which they thought would be fertile ground. They struck out there, so the Dayton town luminaries thought it would be a good idea to invite the ACLU to launch its test case here in Dayton. It would have been good publicity for the town, after all. They didn't call Robinson the hustling druggist for nothing. The town luminaries wanted to know whether John Scopes would be willing to be the test plaintiff the ACLU was looking for. Scopes had been teaching chemistry and biology as a substitute teacher at the high school, and he had been using Tennessee's state-mandated textbook, A Civic Biology, in his classes. That textbook discussed evolution and human origins, and so using it would have been in violation of the Butler Act. So if anyone in Dayton had violated the Butler Act, it would have been Scopes. Scopes himself didn't remember whether he actually had taught about human origins in his class, but he had nothing better to do that summer, so he volunteered to be the test plaintiff. William Jennings Bryan is perhaps the most misunderstood character in the entire drama of the Scopes trial. He's been largely caricatured as a backwards and antiquarian buffoon, a has-been, and a political failure, out of touch with modern notions of science and progress. H.L. Mencken had nothing good to say about him. He labeled Bryan as the Pope of the Coca-Cola Belt, a hero only to the backward hillbillies of the Deep South, which he caricatured as an inferior species of man, Homo neanderthalensis. Mencken had nothing but sympathy for Clarence Darrow and the defense team, however, who he portrayed as lonely, brave warriors battling against the forces of darkness, ignorance, and religious superstition. Bryan's reputation was also smeared by the authors of that 1950s agitprop theater, Inherit the Wind. According to the script, Bryan was a garrulous glutton who dropped dead of humiliation at the hands of Clarence Darrow's relentless questioning, who used truth and logic as his primary weapon. It was the most dramatic part of the Scopes trial, but it was a publicity stunt that played out on the Ray County Courthouse's north lawn. And while Bryan did die in Dayton, it was 5 days after the trial of a stroke he suffered in his sleep. He didn't die a defeated man, though. as was portrayed in Inherit the Wind. By John Scope's own account, the trial ended with Bryan upbeat and looking forward to his next battle. And by any objective measure, it was Bryan, not Darrow, who had the stronger case in the Scopes trial. And it was he, not Darrow, who carried the day. You wouldn't know it, though, because Bryan committed the ultimate progressive sin. For years, Bryan had been writing and speaking eloquently against the prominence of Darwinian thought in popular culture. His argument was against the shape-shifting ideology of Darwinism, which for years had been enlisted in a variety of pet causes, some of them flatly contradictory to one another. Let's call this popular Darwinism. Bryan's argument was that popular Darwinism had no solid philosophical foundation. It could mean anything at all, which, according to Bryan, would lead people to the conclusion that there was no meaning to anything. Bryan made the argument that this fostered an attitude of nihilism among the young, which cut the cultural foundations out from under our society. It was an argument that resonated strongly in the largely agrarian South at that time. For most of the early 20th century, schools in the South, including here in Tennessee, were largely locally run and locally paid for. It was parents and churches who took on the primary responsibility of educating their young and establishing a moral foundation in them. Family was everything. It was a system that worked quite well in the agrarian South. The rise of anti-evolutionism in the South was largely motivated by a move to take education out of local control so that it could be put in the hands of either the state or the federal government, or in the hands of progressive activists like the ACLU, coming in and presuming to dictate to the people of Tennessee how they should educate their young. To Bryan, this move to seize control of education was the new cross of gold, and it was a sentiment felt throughout the agrarian South. And Bryan's anti-evolution campaign proved to be the focus for parents and local schools to reassert control over education. This was the real issue at stake in the Scopes trial, and this is why Bryan and his prosecution team were the ultimate winners in the Scopes trial. Even though the defense got the conviction that they wanted, their plans for an appeal were thwarted by a technicality over how the fine was imposed on Scopes by the judge, John Ralston. And the Butler Act remained on the books in Tennessee for another 42 years. The entire Scopes trial controversy started off as a publicity stunt. The real instigator was George Rapplier, a New York mining engineer who ran a local coal mine, which went bust. Frank Robinson, the hustling druggist, bought into Rapplier's scheme to bring the ACLU to Dayton because he thought it would bring publicity and commerce to Dayton's then faltering economy. The publicity angle worked very well, and it provided enormous color and fodder for visiting journalists to write home about. We're still talking about it today, in fact. At the time, nearly every hotel room in the town was filled with reporters and spectators. Reporters were squeezed into any available space where a cot could be set up. There were celebrities galore who could be relied on to provide colorful copy. There were even staged publicity events, including fisticuffs staged for the amusement of the public and that reporters could write and talk about, and this included radio reporters. The Scopes trial was the first in the nation to be broadcast over radio networks, and several million people listened to the proceedings on WGN, broadcast out of Chicago. I spoke to Pat Guffey, who is the Rhea County historian, for her perspective. There are a number of things about the history of the Scopes trial that I think are quite interesting, and so, for example, I've read that for a time the people of Ray County and Dayton were a little bit embarrassed by the Scopes trial, and gradually that attitude changed to becoming something to be celebrated.
Right.
What can you tell us about that?
People have gradually, I guess, just, it's been here so long and it keeps coming up every year till people have come to, shall I say, work alongside it. Some of the things were so uncomplimentary of Dayton and Ray County when things first came out, when events were first celebrated and information first came out in newspapers, and especially in Inherit the Wind. That was probably the worst blow to Dayton and Ray County that could have been made. I mean, it was just horrible. It didn't even tell the truth. I don't think there was anything in it that was the truth. It was true Hollywood made, laid, done. And they didn't care what they did to this town, whether they blew it off the map or not, or that's the way it seemed. And people were just through with it after that. And I've heard more people say, I don't want to hear any more about the Scopes trial. I'm over it. So when Dr. Cornelius came into the picture, he started gradually working with some of the people. He dug into it and found out who had relatives that were in during the Scopes trial that had ties to it. And so he would contact us. And during, I believe it was the 75th, he contacted a number of us and had us go to Bryan to celebrate what our relatives had done. And our relatives were probably embarrassed over it to the point they didn't talk about it. Our families didn't talk about it because they didn't want any part of it. But newer people, too, have come in and they have produced an excitement about it that has made people here and now become more into it, I guess you'd say.
So when you say your relatives were they embarrassed because of the kind of slander of Dayton's reputation that came from Inherit the Wind?
Right.
Yeah. Okay.
All the monkeys and this has been called Monkey Town, and people today still say Monkey Town, and they have names for some of their businesses. And a lot of the older generation do not like that. They tolerate it, but they don't like it. They don't say anything, but
I've got that sense from talking to people around here. They're very different reactions to the term Monkey Town. So then, Dr. Cornelius and Bryan College, they were kind of the initiators for this change of attitude towards the Scopes trial.
Well, Dr. Cornelius was, and he got a group together that started doing play then.
Now, if you call them periods, they may have been going on for a very long time. They might have been.
It's been a money maker for that group. For the Bray Heritage Group.
So did when he was talking to you, was he mainly trying to reach out to people who were a little bit embarrassed by the legacy of the Scopes trial, to try and bring them along, to make them see that, or to help them see that this was actually something to be celebrated and to be proud of?
I think he probably was. I know he was what he did at first was to put plaques on various buildings that had to do with a person involved in the Scopes trial. Like my great-grandfather was the attending physician, and he signed the death certificate. He was called over there because he lived close by. And he wanted to put a plaque on my home place, and on the barber shop where a fight was instigated, and the boarding house where Scopes lived, and and the Hotel Aqua where people ate during the trial, and just different places.
So the fight was between George Rallier and the barber, right?
Yeah.
And it was staged,
It was
apparently?
that was staged. Yes, yes.
Is there a record of it's being staged anywhere, or?
In Randy Moore's book, The Field Guide,
Okay.
there's a record of it.
Yeah,
Yes,
yeah.
and I assume it's in other places.
Okay, all right.
I'm not a total authority on it, so
Okay.
I haven't read everything on the
Yeah,
Scopes trial.
yeah. Um, any other kind of colorful things about the Scopes trial? I know it was portrayed in Inherit the Wind as a kind of carnival atmosphere, but there was definitely a kind of real carnival atmosphere here. People came in, they had the banners, Joe Mendy was here, and so forth. So what can you tell us about that?
Well, my grandmother and great aunt, they were the daughters of my great grandfather, who was the attending physician. They went to the trial every day. They walked from South Dayton up here to the courthouse. And they said there were people selling food on the side of the street, drinks, soft drinks, things like that. That people were selling anything they could, any kind of souvenir for the Scopes trial.
Mm-hmm.
Little monkeys, key fobs, everything was sold.
Interesting. Yeah. And you apparently are a distant relationship with Charles Darwin.
Very distantly, but I attended Darwin family reunions for a few years till we had to quit because everybody got too old to travel. And we had no historian at that time. She passed away. But yes, one of our members had traced our lineage back to Charles Darwin. It is distant, but it's there.
Mm-hmm.
And my great grandmother was a Darwin. She was from Evansville, which used to be called Darwin Station.
Oh.
It was named after the Darwin family that settled here because there were so many of them, and they were very wealthy. They first settled in Old Washington, which was the capital of Ray County before Dayton became the capital.
Mm-hmm. Yeah.
Part of the Darwin family then moved to Evansville, and her family was part of that group. Her father was captain in the Confederate Army, so we go way back.
Yeah.
But she became a bride of 16, and my great grandfather, Dr. Walter Thomason, built a house for her down in South Dayton.
Mm-hmm.
And he was the one that was the attending physician.
Okay.
So Brian.
Yeah. So when you say you got together for family reunions, it was the Darwins of Tennessee.
Darwins all over the United States.
All over the United States, really.
Some of the Darwin brothers, there were brothers. One of them went to Huntsville. One settled in Ray County. One settled in Middle Tennessee.
Yeah.
So they settled all over and had children going all over the place.
Okay.
They originally came from Virginia to South Carolina to Ray County, Middle Tennessee, Huntsville, Texas, somewhat to Texas.
And when did they come here then?
Early 1800s.
Early 1800s. And apparently, what the man who owned the furniture store, his surname was Darwin. He was a relative of yours.
He was my great grandmother's brother.
Okay. Yeah.
And he married a lady from Meigs County, Decatur area, which was across the river. Her father was a state representative, and they lived just down the road or down the street from my great grandmother, great grandfather. Yeah. So they visited real often, and he had 4 sons.
And he apparently exploited his name in kind of a clever way during the Scopes trial, right?
Yeah.
What did he do?
Darwin is here inside.
Okay. All right.
Yeah.
So, is there anything else you'd like to add to the?
My great aunt met a reporter. She had studied at Columbia University in New York, and she studied fashion designing. She had a knitting business here, and later on she designed and made wedding dresses and other clothes for people. And she went every day to the trial to see the styles. And she met a reporter who was there, and apparently they had a few days. So that was another thing that came out of it. And I guess she probably wasn't the only one. There were probably others that dated reporters.
Yeah. Yesterday, after the symposium, there was a Baptist minister. I think his name
Bird.
What's that? No, it wasn't Bird. He was from
his relatives were here.
Okay.
Yesterday.
Yeah. Anyway, there's a group of three of them out there in the corner. But then on Sunday, apparently the Freedom from Religion Foundation is going to be making a visit here from their conference in Chattanooga. Complete.
Oh, really?
Complete opposite sides of the shall we say religion science issue. And
well, I think people now are looking at both sides.
Yeah.
And they think a little differently than they did at that time. Hopefully 100 years have changed a lot of things.
I think it has, actually.
Yeah.
I think it actually has, yeah.
And I taught biology at the local high school.
Oh, did you? Okay.
30 years, so I saw things changing.
Was evolution on the curriculum when you taught it, or it was? Were they still using civic biology when you taught it?
It was just called biology, but it had evolution. Of course, all the textbooks had evolution.
Yeah.
And a lot of people did not want it mentioned here.
Yeah, really? Okay. Yeah. And so was it not on the curriculum then? You said...
It was supposed to be, yes.
Yeah.
I tried to teach both sides of it, evolution and creation. And it let kids think for themselves. So that they're, I didn't want to just teach one way. I wanted them to see both sides and what was involved in both, and to think for themselves, which a lot of students do not do. I don't think a lot of parents encourage their kids to think for themselves anymore. They're too busy.
Yeah, I think so, yeah. I see someone outside wanting to come talk with you, so I'm going to say thank you for your...
Well, you're welcome.
For your talking to me, and I've really enjoyed this celebration this year.
Well, I'm glad you came.
History has been more kind to Bryan's opponent in the Scopes trial, the Chicago celebrity attorney Clarence Darrow. Unlike the prosecution, which had a fairly straightforward case to make, namely, did or did not John Scopes violate the Butler Act, the ACLU and Darrow had a more convoluted case they had to make. Even though they were ostensibly for the defense, their motivation was also to get a conviction. They needed a conviction to mount their appeal to a higher court to have the Butler Act declared an unconstitutional infringement of free speech and freedom of religion. Darrow was a prominent member of the ACLU, which had brought the case and which had enlisted their show defendant, John Scopes. Darrow had a long and flamboyant legal career. He represented the American Federation of Labor at a time when the labor struggle was marked by terrorist bombings and anarchy. Accusations of jury tampering phased out his career as a labor lawyer. He continued as a prominent criminal defense attorney, though. In 1924, just prior to the Scopes trial, Darrow took on the case of the infamous boy murderers Nathan Leopold and Richard Loeb, and their notorious thrill murder of the 14-year-old Bobby Franks. It was that decade's trial of the century. He managed to get Leopold and Loeb spared from the death penalty by arguing that they were too young to be responsible for their crime. It was a case that had shocked the nation, and it seemed to encapsulate the dangerous nihilism that was the mainstay of Bryan's criticism of Darwinism and evolutionism. So when he learned that Bryan would be representing the prosecution against John Scopes, Darrow leaped at the chance to face off against Bryan and offered his services for the defense. Given his controversial reputation, the ACLU didn't really want Darrow on the case, but was brought in nevertheless on the insistence of John Scopes. Because the defense really didn't want an acquittal, Darrow's case relied substantially on deflection and histrionics. The defense had brought in a large number of expert witnesses to testify about the, quote, truth, unquote, of evolution and Darwinism. The judge, John Ralston, was having none of it. After hearing the testimony of one of the experts, Ralston ruled that none of the defense's expert witnesses would be allowed to testify, as their testimony would be immaterial to the legal question at hand, namely, whether John Scopes had violated the Butler Act. This set off a confrontation between Ralston and Darrow that ended up earning Darrow a contempt citation from the judge. Darrow had to apologize, and Ralston lifted the citation. There were various other histrionics. One centered around a banner that was hung on the outside wall of the courthouse, exhorting people to read their Bible. The banner behind me is a facsimile of the original. Darrow objected to the presence of the banner as prejudicial to the defense's case, demanding either that the banner be taken down or that another banner be put up exhorting people to read your Darwin. It seems like a principled stand until you remember that a conviction and a prejudicial case was exactly what the defense wanted. Pure deflection. By far, the highest profile histrionics came when Darrow, having been refused the testimony of his expert witnesses on evolution, instead proposed to call William Jennings Bryan to the stand as an expert on the Bible. Ralston was initially skeptical of this tactic, but Bryan was willing, setting the stage for the ultimate publicity stunt of the case. Because of concerns over the excessive heat in the courtroom, as well as worries that the large crowds in attendance were putting too much stress on the courtroom floor, Darrow's interrogation of Bryan was moved to a platform outside the courthouse, on the courthouse's north lawn. According to the popular narrative, helped along by the misleading script of Inherit the Wind, Darrow supposedly made mincemeat of Bryan, catching him in contradiction after contradiction, leaving Bryan humiliated to the point that he collapsed on the spot and died. However, Bryan ended the day upbeat. He had defended his point of view in front of the largely sympathetic local audience, and he was looking forward to turning the tables on Darrow in a similar public confrontation planned for the next day. Again, Judge Ralston was having none of it. He ordered Bryan's testimony to be stricken from the trial record as immaterial to the matter at hand, just as he had for the defense's other expert witnesses. With that, the case was remanded to the jury, who, within hours, returned the expected verdict of guilty. With the guilty verdict in hand, Judge Ralston imposed a $100 fine on Scopes, which was covered by the ACLU, and Mencken's newspaper, the Baltimore Sun, put up the $2,000 bond pending appeal. The ACLU had the conviction it wanted, but their plan to appeal the guilty verdict was thwarted, and the verdict against Scopes was thrown out a year later by a higher state court. I've often wondered whether Judge Ralston made a mistake or whether he had actually outfoxed the ACLU. Did he know that in fining John Scopes from the bench, he was setting up the grounds for the case to be dismissed and the ACLU's plans thwarted? For this year's centennial celebration of the Scopes trial, there was a two-day symposium titled Evolving Conflict that brought together 8 speakers who were thoughtful, diverse, and full of disagreement that was informative and civil. First off the bat was Nick Spencer, a senior fellow at the Theos think tank in London, in the UK. The focus of Theos is on the interface of religion and all aspects of civilization, including science. He spoke about the ongoing relationship of science and religion, and his main message was that the supposed war between science and religion is very complicated. For most of human history, science and religion seem to have got along quite well, except when both became overtly political. Jerry Summers is a local attorney, and he had some interesting reflections on the legal issues around the Scopes trial and some of the interesting personalities that were involved, in particular the judge in the Scopes case, John Ralston. Ed Larson is a professor of law at Pepperdine University and is the author of the Pulitzer Prize-winning history of the Scopes trial, Summer for the Gods. He had some reflections on the social implications of the Scopes trial. And rounding out the first day was Randy Moore, who is emeritus professor at the University of Minnesota, who spoke about the real John Scopes, drawn from his new biography of Scopes. On the second day, Neil Duran, who is a professor of biology at Bryan College, here in Dayton, spoke on the state of evolutionary science at the time of the Scopes trial. Neil Duran is a creationist and is head of the Creation Research Institute, based here in Dayton. Next was John Hawks, who is a professor of evolution at the University of Wisconsin, and he spoke about our current understanding of human origins, and in particular, comparison with what was known and unknown about human origins in 1925. Joel Duff is a professor of biology at the University of Akron. In addition to his scientific work, he also has a deep interest in the intersection of science and Christian faith. He spoke on the extensive history of Christian faith and evolutionism, with a particular focus on the compromise position of theistic evolution. And finally, Todd Wood spoke of the evolution, if you will, of creationism following the Scopes trial. He has a particular scientific interest in computational biology and protein evolution, and he is also the founder of the Core Academy of Science, which describes itself as a creation ministry. During my visit here in Dayton, the people I've encountered have been unfailingly polite and welcoming and helpful. I do get a little good-natured joshing about the twin strikes of being from California and New York, but it's all in good fun. However, mention the movie Inherit the Wind, and the reaction will be ambivalence bordering on annoyance. Almost uniformly, the people of Dayton that I've spoken to resent Kramer's caricature of the South, Southerners, and Dayton in particular. They're proud of their community and of the role they played in one of the most significant events of the early 20th century. The main way they express their pride is the annual celebrations on the anniversary of the Scopes trial, and the center of those celebrations has long been the staging of a play, Destiny in Dayton by Frank Chapin, as a kind of counter-Inherit the Wind. It's staged right here in the Scopes trial courtroom. I spoke to Tom Davis of the Rhea Heritage Preservation Foundation about Destiny in Dayton. I asked Tom Davis what were the origins of Destiny in Dayton.
In '88, Frank Chapin, who wrote Destiny, came to town wanting to produce Inherit. But somebody suggested he go to talk to Dr. Richard Cornelius at Bryan College. And Dr. Cornelius showed him the transcript. He read it and agreed that there's more good stuff in the transcript than in Inherit when it comes to the Scopes trial. So he sat down basically and wrote Destiny, and the college produced that for 10 years, produced another script for 10 years, and there have been 2 or 3 others in the meantime. 3 years ago, we went back to Destiny, this time with the permission of Frank's co-author. We added the character of Nellie Kenyon, who acts as kind of a narrator to help set the stage, bridge the gaps in the script.
The defense went on to define the theory of the case, how there is no conflict between evolution and Christianity, and that they had a house full of scientific experts that could prove that very thing.
and then wrap it all up at the end. But it's essentially the same production.
In this scene, Clarence Darrow interrogates William Jennings Bryan as an expert witness on the Bible. In the actual trial, Bryan's testimony was staged on the courthouse north lawn.
Use your own definition to explain what I say, and I will use mine in answer.
Do you believe the story of the flood to be a literal interpretation?
I think it is.
When was that flood?
I never made a calculation.
Oh, a calculation for what?
I cannot say.
The generations of man?
I would not want to say that.
Well, what do you think?
I do not think about things I do not think about.
Well, do you think about things you do think about?
Well, sometimes.
But typically, is cross-examining his own witness.
He is a hostile witness.
I will let Mr. Bryan control.
Your Honor, I want him to have all the latitude he wants. For I will expect some latitude from him later.
Oh, you can have latitude and longitude.
No, Your Honor. These gentlemen did not come in here to try a case. Why, they came in here to try revealed religion. And I'm here to defend it. They can ask me any question they please.
Right?
Great applause from the bleachers.
From those you call
I
yokels.
never called you a yokel.
Oh, that is the ignorance of Tennessee, the bigotry.
I mean those who applaud you.
Those are the people whom you insult.
And you insult every man of science and learning in this world because he does not believe in your full religion.
I will not stand for that.
For what he is doing.
I'm talking to both of you.
This has got to be on the tail of the lawsuit. I ask that they stop.
To stop now would not be just to Mr. Bryan.
I asked Tom Davis why was Destiny in Dayton staged rather than just a recreation of Inherit the Wind.
I was not a part of that decision, but from what I understand, again, this was a college-sponsored event named for William Jennings Bryan, and then as I was involved, we realized that this was a very significant part of Dayton's history, of American history, really. And of course, it was the foundation for Bryan College. So the group, when I got into it, really wanted to tell the story. In the late 80s, I think Inherit was much more widely produced, and by that time it had kind of won the battle of, is this what really happened? And we wanted to tell the truth in an entertaining way.
In this scene, Tom Stewart, the state attorney general, interrogates Walter White, superintendent of the Ray County Schools, about whether the ban against teaching evolution was constitutional. The defense objects when Stewart tries to enter the Bible into evidence.
And you were discussing this new law that passed.
Yes, sir.
And that law passed what, March 21?
Yes, sir. He said he could not teach biology without breaking the law.
And he said that he taught evolution here in Ray County.
Yes, sir.
He said it was unconstitutional.
He said the statute.
Mr. White. I ask you, is this the King James Version of the Bible?
Do you mean to file that into evidence?
We authored it.
Your Honor, we object to the Bible or that book from going into evidence, and we ask that the prosecution prove what the Bible is.
Overruled. Let it be introduced as the Bible.
What are you going to introduce? The whole book? Each of us read from it such passages as we choose.
You may inspect it and cross-examine the witness about it.
Do you know where we can get a copy of that same book?
Robinson's Drugstore.
This same Bible can be secured without difficulty.
This small town, I don't know.
If you can't get that here, you can get it in some other town.
You may cross-examine if you care to.
And at that point, it was probably more help people understand the creation evolution aspect of the trial. As we've gone through it, we've realized that creation evolution is not quite the hot button issue that it was even 30 years ago. But things like parental involvement, the role of government, the role of religion in society, really is where the country is today. And it's not a stretch to read the transcript and see that that's what they were talking about, is much or more than creation and evolution in 1925.
Early in the trial, 2 of John Scopes' students testified that Scopes had taught about evolution in his class, thus establishing his guilt. Turns out that Scopes coached their testimony because he had not, in fact, taught about evolution.
Repeat that. And if I don't get it right, you correct me. Now, he said that in the beginning, the earth was a crystalline mass. It was too hot for life to exist, and it cooled. The soil and the seafloor, plant life on the earth and in the sea, animal life began with a little one-celled atom.
Yes, sir.
Which evolved, and it got bigger, and it became a land animal.
Yes, sir.
The combination of which was man.
Yes, sir.
Did he say that there was...
Would you mind asking what he said?
Yes, sir, I will do it. Now, when was it he taught you this?
During class in April.
And the theory that he taught you, could you find it in that book?
No, sir.
I hand it to you, gentlemen, to find it. Now, how did he classify man with reference to other animals?
Well, the book and he both classified man along with cats, dogs, cows, monkeys, horses, lions, horses, all that.
And what did he say they were?
Mammals. He said they were mammals.
And you say this was along about the 2nd or 3rd of April this year?
Yes, sir.
That's all. You can cross-examine.
Let's see, your name is what?
Howard Morgan.
Now, Howard, what do you mean by classify?
Well, it means these animals we mentioned, men were just a set.
Well, he didn't say a cat was the same as a man.
No, sir. He said it may have had a reason how these animals were not.
Well, there's doubt about that. That is what he said.
But, some men.
A great many, Mr. Stewart. Now, Howard, he said they were all mammals?
Yes, sir.
And did he tell you what a mammal was? Or you have forgotten?
He just said that these animals were mammals and mammals.
And he said they were all mammals?
All what?
Dogs, horses, monkeys, cows, man, whales.
I don't know about the whales. He said all those other ones, but I don't remember the whales.
And he said the earth was once a molten mass of liquid.
Yes, sir.
And that the first life was in the sea, and that developed into life on land, and finally into the highest organism known as man. Now, that is about what he taught you, is it?
Yes, sir.
I asked Tom Davis how Inherit the Wind fell short of a fair representation of the trial.
Okay, it's been a little while since I've watched Inherit, but what comes to my mind is that they were trying to make a point, I would say, about freedom of expression, probably even more than the science, religion, creation, evolution controversy. And they certainly did that. I'm not convinced that they really did justice to either Bryan or Darrow. They weren't trying to be accurate. They were trying to make their point. Lawrence and Lee were trying to tell their story, and they did it very effectively and did it very well. But part of what we're trying to help people understand is that story is not history. That's a parable about history. What we do here is history. So, is it fair to compare an apple and an orange?
I asked Tom Davis if there were plans to take Destiny in Dayton to a wider audience than just Dayton.
Absolutely. Last weekend, we didn't do it, but the Bryan Birthplace organization in Salem, Illinois did. We've had a good relationship with those folks over the years. And with the Centennial, they knew about our production. They wanted to do it up there. Well, last weekend we were here, so they went ahead and got the script and did it. I haven't had a chance to find out how it went. But Destiny has a cast of about 25, which is way beyond our means to take on the road. But during COVID, of course, we shut down everything. In 21, late in the winter, we started talking, can we do a production this year? And, it wasn't until probably May that enough of the don't do this, don't do that had lifted. But through that process, we contracted with a young playwright to write a 1-hour show, a 1-act play. We call it How It Started. And cast of 4 to 6, depending on how you want to stage it, which is very transportable, very suitable for a school production or something like this. And we've actually taken it on the road once. We've done 2 years of inviting school groups to come here in the spring and do that for them. We combine that with a lecture about the issues and then a tour of the museum. But that was very, very well received. And really that's what we're after, to help anybody, but school children particularly, as they're dealing with many of these issues, to see, okay, this started 100 years ago, and we're still dealing with it.
I asked Tom Davis about the legacy of the Scopes trial and how Destiny in Dayton expressed it.
I mentioned it a little bit this morning. The idea that in 1925, the lawyers could argue just as passionately as they could, and then leave the rancor in the courtroom and go out and socialize, be considerate of each other. That's something that we as a society desperately need. And, I hope with the symposium that we've had, that we're having, and even with the play, people can catch a glimpse of that, because, we had a variety of opinions and presentations that I'm sure made some people say, wait a minute. But we discussed it, and hey, we can walk out of here friendly. The other thing that impresses me more and more is in 1925, nobody had heard of Dayton, and people here had a need. An opportunity arose, and they stepped in and said, let's do something. 100 years later, we're talking about that. And that just reminds me that Washington, D.C., and Los Angeles and Chicago are not the only places where big things can happen. And even if my hometown doesn't have a Scopes trial in its history, we've probably got something that we can be proud of. And it just takes some people to say, hey, let's celebrate. Let's rejoice in what we have, who we are, and invite some people to join us. I think pride of place is critical to a good community. And, we live in a country that we have a lot to be proud of, but it's made up of little places that we have a lot to be proud of.
What of John Scopes, the defendant in the Scopes trial? What's his story? Scopes himself has long been the enigmatic cipher in the Scopes trial drama. He became the defendant casually, agreeing to step up over Coca-Colas at Robinson's drugstore. He had substituted for the regular biology teacher for about 3 weeks, so if anyone had violated the Butler Act, it would have been him. Never mind whether he actually had. He never spent a single second in jail, nor was he ever under any real legal jeopardy. After he had signed on, he went back to playing tennis. He was hardly a latter-day Galileo. During the trial itself, Scopes said nothing. Well, that was his right as a defendant. But according to his memoir, published several years after the trial, the ACLU had made it abundantly clear to John Scopes that his job was to sit at the defense table and keep his mouth shut. His only words that were to be entered into the trial record came when he was found guilty, and the judge asked him if he had any words for the court before sentence was imposed. Scopes simply said that he felt he had been convicted under an unjust law and that he believed in academic freedom. Following his trial, John Scopes largely faded into obscurity. This was his deliberate choice. He assiduously avoided public attention. He rebuffed requests for interviews and passed up opportunity after opportunity to tell his story. Notoriety did follow him. His ambition was to be a teacher, but his applications for employment as a teacher after the trial were uniformly turned down. His notoriety spread a bit to other members of his family. His sister, Leila, was dismissed from her position as a teacher in Paducah, Kentucky, where the Scopes family was raised and where Leila still lived. But opportunity also followed him. A group of prominent scientists organized an equivalent of a GoFundMe campaign, ostensibly to aid in his defense. They wanted to raise about $5,000, but managed to raise only about half that. His legal expenses were covered by the ACLU, though, so Scopes decided to apply the money to enroll in graduate school at the University of Chicago, where he studied geology. Eventually, this money ran out before he could complete his degree, so he took employment as a field geologist with the Gulf Oil Company, which sent him to Venezuela and the rich oil fields that were developing around Lake Maracaibo. He was successful there, hardworking and well-liked by his colleagues and employers. He eventually earned enough money from that to finance a return to graduate school, but that money also ran out before he could complete his degree. In the meantime, Scopes had met and married his wife, Mildred, and they began their family. He continued working as a geologist in the oil industry, which took him to Houston and eventually to Shreveport, where he lived for the rest of his life. He died there in 1970. He had a brief flirtation with a political career, running for the U.S. Congress as Kentucky's at-large representative on the socialist ticket. He lost decisively, which put an end to that flirtation. In short, John Scopes' story was that of the stereotypical everyman, quiet, out of the spotlight and comfortable there, and getting on with his life as best he could in the landscape of the opportunities and inevitable setbacks that mark every life. Later in his life, Scopes began to open up a bit about his story. The movie director Stanley Kramer had decided to make a film out of Jerome Lawrence's and Robert E. Lee's play Inherit the Wind. Kramer enlisted Scopes to help promote the movie, which earned Scopes quite a bit of money. He came to Dayton for the North American premiere of Inherit the Wind, where it was shown at the Dayton Drive-In Theater. He even made some television appearances on talk shows and game shows like To Tell the Truth.
One of these men was the defendant in the most famous court trial of this century. What is your name, please?
My name is John Thomas Scopes.
What is your name, please?
My name is John Thomas Scopes.
What is your name, please?
My name is John Thomas Scopes.
Two of these people are imposters. Only one is the real John Thomas Scopes, and is the only one sworn to tell the truth.
He didn't pursue publicity, though. He remained reticent. Eventually, he met the journalist James Presley, who persuaded Scopes to allow him to help tell his story. The result was The Center of the Storm, released in 1967. For years, The Center of the Storm was the only definitive source of John Scopes' modest and unpretentious life. It's a great read, but for various reasons, it falls short of being an authoritative source. Both John and Mildred Scopes struggled with alcohol abuse and addiction. Things got bad enough in the Scopes family that their sons were sent off to live with their Aunt Leila for 3 years. Years that the sons later described as the best years of their lives, presumably because it allowed them to escape what seems to have been a dysfunctional family. John and Mildred Scopes divorced and eventually remarried. So there were some definitely dark undercurrents in the Scopes' later life, which did not come through in The Center of the Storm, for obvious reasons. No one likes to explore dark corners of their lives. At this year's centennial of the Scopes trial, Randy Moore, a retired professor of biology, unveiled what will prove to be the authoritative biography of John Scopes, titled simply John Thomas Scopes, a Biography. It's available from Bloomsbury Academic Press. Moore has done the hard work of scholarship and journalism that did not come through in The Center of the Storm. He did what journalists normally do. He looked for as wide a variety of untapped sources about John Scopes and wrote from that. And the major untapped source about John Scopes' life was his own family and friends, who had largely been overlooked by journalists who preferred simply to print boilerplate about the trial. And it's from those sources that we get the best answer yet for whether John Scopes actually had violated the Butler Act. Scopes himself was inconsistent on that question. At times he would say that he didn't remember. Other times he would say that probably he had. And at still other times, Scopes would say that he definitely had not taught about evolution. Randy Moore settles this question by getting hold of copies of the exam that John Scopes set for his class, which did not include a single question about evolution or human origins. Based on that, it's pretty certain that John Scopes had not violated the Butler Act. It's from those sources that we learn about John and Mildred Scopes' struggles with alcohol and the significant role that played in his own family dynamics. Remarkably, alcohol played a role in Scopes' own memoir, The Center of the Storm. He and James Presley had met during a drunken party, for example. To call Scopes and Presley co-authors is a bit of a stretch. The book was actually written largely by Presley, who has a real gift for narrative. Scopes would feed Presley stories and recollections, often while he was drunk, which Presley hammered into readable prose. Both Presley's and Moore's books paint out a full picture of John Scopes as an admirable, reticent, and flawed man who was nevertheless motivated by deeply and quietly held ideals. And that is the story of John Scopes. Here is where the legacy of the Scopes trial becomes problematic. At the heart of the Scopes case was a fundamental question. Who gets to decide how we educate our children? Or, for that matter, who gets to decide how we live our lives? The U.S. is a highly pluralistic society. There are a lot of different kinds of people living here, with different points of view and different histories. And there's lots of opportunity for conflict and contention in there, and that's never going to go away. A few days previously, a Baptist street preacher showed up in Dayton on the corner of Market and 2nd Street, right here, just outside the Ray County Courthouse.
God made the laws of science.
That's right.
Man discovered those laws, but they were made by God.
Amen.
And in those laws of science, those very laws that God made, they refute the theory of evolution.
Nope.
They refute the lies of evolution. Every time evolution has found their missing link, lo and behold, it's either a lie or something totally different. Oh, this tooth, it's the missing link. Oh, nope, wait a minute, it's just a pig's tooth. Oh, this jawbone, it's the missing link. Oh, nope, it's just the jawbone of a woman of current day. Evolution has never been able to prove one point of their indoctrination. Never.
So what's your perspective on the Scopes trial?
Well, first of all, I'm Greg Wilson. I'm the pastor of New Song Baptist Church in Macon County, Tennessee, or Lafayette, Tennessee. And we're down here because we feel like there needs to be another perspective given. We don't feel like what's being presented inside the courthouse is fair. And we want to give as much of an argument as possible to the people of Ray County. I love the people of Ray County, but I'm disappointed. I would love to have them out here with me. And I'm disappointed that we're the only voice today. If God allows us, we'll be out tomorrow, and then we'll go home. But the perspective on the whole Scopes trial is that there is one struggle in all of, you can say, in all of the ages, and that's the struggle of authority. That struggle goes between nations, it goes between political parties, it goes between neighbors, where is my fence line supposed to be? I've seen it over and over again. We're not going to settle it. I'm not going to settle it, and they're not going to settle it. But we need to have a free voice to tell our side. I'm thankful today that we have the First Amendment to stand out here and tell our perspective. We have having free speech. Now, the Scopes trial is what it is. It turned out the way it is. It did. And maybe if someone would challenge it, it would go the other way.
It's fair to say that anti-evolutionism and religious fundamentalism is still a strongly held sentiment in Tennessee. And it happens to be a strongly held sentiment everywhere in the country, actually. And it's not just among fundamentalist Christians. The growing Muslim population in the United States is as averse to evolutionism and Darwinism as any fundamentalist Christian preacher. Today, for example, there'll be a delegation from another group of fundamentalists, the Freedom from Religion Foundation, which has been holding its own Scopes Centennial Conference in nearby Chattanooga. They'll be visiting the Scopes Trial courtroom, which will be opened for them for a special Sunday tour. It's also fair to say that this delegation will be as rock hard in their beliefs as that Baptist preacher is.
I mean, if you look at America's prison population, who is disproportionately represented? True believing Christians. And who is rarely to be found? The atheists. And so here we are in Dayton, Tennessee, where the Rayette County Courthouse just recently posted its own 10 Commandments in a loud proclamation that in this house, we believe in a jealous God over secular justice. What about the stark realities that anyone with a mind open to reason can see? Well, you know, that read your Bible, that's theirs. This is ours. And even if there are setbacks on the horizon, we will be victorious. The truth will win out. Your values, my values, will withstand what is to come and be stronger for it.
Do you know the word reverend was a typo? Did you know that? No. The first letter used to be an N. I was here more than 20 years ago when FFRF sued Ray County over the Bryan College teaching Bible classes during school days, and we won that case, and we even won on an appeal. This might have been ground zero for that fight over evolution and faith, but it's still ground zero for the current social conflict that we are having right now.
I'm going to make a prophecy, and if I'm wrong, you can dig me up and tell me. 100 years from now, there will be some other people, probably most of them never born, standing in this spot for the 200th anniversary, the bicentennial of the Scopes trial. And even though 100 years ago it was ground zero, I'm going to prophesy that 100 years from now, the controversy will be pretty much zero. The acceptance of the truth of evolution will prevail. Why? Because it's the truth.
Darwin's idea is a soaring cathedral of an idea. When Clarence Darrow dramatically called William Jennings Bryan to the witness stand, he cross-examined him on biblical absurdities such as God causing the sun to stand still in the sky, postponing sunset to give Joshua more time to massacre the Amorites. He could as well have drawn attention to the undignified absurdity of the creator of the universe stooping to engineer a cosmic catastrophe for the sake of anything so squalidly parochial as extra time for a skirmish between two human desert tribes.
To quote from one of the symposium participants, Nick Spencer, in his book Magisteria, these two groups encapsulate the, quote, conflict between fundamentalists who disbelieve Darwin and fundamentalists who disbelieve anything that isn't Darwinian. How do you accommodate those fundamentally opposed viewpoints in any single legal dispensation, in a single school system, across a whole state like Tennessee, across an entire country? The simplest answer to this question is that you can't. For years, jurisprudence on this issue has been focused on the Establishment Clause of the First Amendment. That seems to be breaking down. And finding a single accommodation for everyone in this diverse country is likely to get more difficult, not less so. The issue has been inflamed by ever bolder attempts to work in some pretty radical ideologies under the protective cloak of science. Climate change comes to mind. An especially hot-button issue right now has been transgender ideology and sexuality. In both these instances, and others, the world is split into, quote, approved science, close quote, and, quote, science deniers, close quote. Where there should be skepticism and open debate, there is instead censorship and exclusion of opposing viewpoints that converge into downright bullying, all backed up not by knowledge, but by political power masquerading as science. Along with this has been a growing tendency for schools and school boards to simply ignore what parents want for their children. The message seems clear. Parents are expected to just pay up and shut up. This attitude was infamously expressed a few years ago by Terry McAuliffe, who was then governor of Virginia running for re-election, and who said he didn't think parents should have a role in setting the curriculum for their children in the public schools. It didn't work out well for him. Recently, in the case Mahmoud versus Taylor, the U.S. Supreme Court seems to have opened up a new avenue of accommodation to try, ruling that parents have a right to take their children out of lessons that they find religiously objectionable. In this instance, it was objections to schools teaching young children about sexuality, including transgender ideology. Allowing parents to opt out might be an improvement, but it's not a solution to the problem of educating in a pluralistic society. Parents opting out of a particular lesson will not take the lesson out of the school. So what do you do about evolution? Will there be an opt-out for parents who object to their children learning about evolution on the same religious grounds? I think the time is not far off when we will begin to see just that. And the time may not be much farther in the future when parents will opt out from a wider range of contentious issues. This will likely mean the end of the public schools. So, what to do? Now, a century after the events here in Dayton, just what is the legacy of the Scopes trial? Well, it depends. As a legal matter, it was pretty inconsequential. The prosecution successfully defended the right of the state of Tennessee to set curriculum in their own schools. The defense's plan to use the case as a pretext for an appeal to have the Butler Act declared unconstitutional was thwarted. John Scopes himself went on to lead his quiet and uneventful life unmolested by the law, and life in Dayton went back to pretty much what it was before. For other reasons, beyond the narrow legal confines of the case itself, the Scopes trial was enormously consequential. We're still talking about it 100 years later, and we may be talking about it still 100 years from now. In terms of precedence, the Scopes case set the stage for at least 10 high-profile legal challenges since 1925 to school boards, both state and local, that had the temerity to want to set their own curricular standards about the teaching of evolution. Lessons were learned. Where the ACLU's 1925 challenge focused on state and local courts, the subsequent challenges have been brought through federal courts. In Dayton, part of the defense's case turned on the Establishment Clause of the First Amendment, forbidding the teaching in any public institution of any theory of human origins that contradicted that outlined in Genesis was, the ACLU asserted, in essence an establishment of religion in the Tennessee schools. That aspect of the defense's case was hampered, though, by there being no Establishment Clause in the Tennessee Constitution. The federal Constitution does, however, so that's where the legal battles have moved. In the federal courts, Establishment Clause arguments have been a consistent winner. In 1968, for example, Arkansas's anti-evolution statute, which was modeled closely after Tennessee's, was overturned by the U.S. Supreme Court on the grounds that it introduced impermissible religious instruction into public schools, thus violating the Establishment Clause of the First Amendment. Most of the subsequent 9 cases have turned on similar Establishment Clause arguments. The latest successful challenge was here, mounted in Dover, Pennsylvania, in the Kitzmiller et al. Versus the Dover Area School District. In 2001, the Dover School Board mandated that alternatives to Darwinism be included in biology instruction in the Dover schools. This time, the bone of contention was intelligent design theory, which was promoting itself as a credible scientific alternative to Darwinism. It still is, by the way. The Dover School Board had set what was actually a fairly benign set of requirements, consisting mostly of a statement to be read to biology classes at the start of the year, that there were alternatives to Darwinism for explaining the origin of species, and particularly the origin of humans. Discussion of these alternatives was to be encouraged. The Kitzmiller case, like the Dayton case, was brought by the ACLU, and it had many of the same elements of the ACLU's legal strategy in Dayton. It included plaintiff shopping, intrusion into the autonomy of a local school board, and a high-profile trial. Unlike in the Scopes case, where the judge had disallowed the testimony of the panel of expert witnesses, the judge in the Kitzmiller case allowed the testimony of scientific experts. They were central to the case, in fact. This was accompanied, as it was in Dayton, by an attendant media circus, fueled by lots of gotcha moments that made the scientific experts feeling pretty good about themselves. There was much virtue signaling in Dover, in short. The judge in that case, the Honorable John E. Jones III, found in favor of the plaintiff, ruling that intelligent design theory was not science, but religion, and so could not be included in the science curriculum of the Dover schools, nor, for that matter, in any of the public schools that fell under the jurisdiction of the Third Circuit. In essence, in any public school in the United States. In effect, you had a federal judge telling teachers and scientists what could and what could not be considered science. I would have thought that my independent-minded scientific colleagues would have been troubled by that, but they weren't. They acted as the proverbial herd of independent minds and cheered a federal judge telling them what did and did not count as science. Where's the academic freedom in that? The only way forward that I can see actually is embedded in the Scopes case, if only we'll glean the proper lesson from it. The issue at hand there was outsiders taking control of education out of the hands of independent school boards that represented the interests of voting parents. Prior to that, Dayton had schools, good schools. Students were being educated. People will support schools as long as they see the schools as representing their wants and desires. In bringing the Scopes case, the ACLU undermined that. They brought the case because they thought ordinary people were incompetent to judge for themselves how to educate their children. And the ACLU seems slow to have learned that lesson. The same issues drove the Kitzmiller case in Pennsylvania. Control had to be taken away, and doing so has blown up in everyone's faces. Schools are no longer instruments of social cohesion, as they have long been envisioned they could be. Now they are arenas of social conflict and contention. So maybe the time has come for a radical return to local control of public schools. Neighbors are more likely to work out differences of opinion and contentious issues, more so than the fad-driven education bureaucrats that now run the show. Parents are the most competent authorities when it comes to their own children, so why not just let them be? Maybe that's the positive legacy that we can all draw from the Scopes trial.